Now, from the Pope John Paul II Cultural Center in Washington, D.C., Raymond Arroyo.
Good evening. Welcome to The World Over Live. A happy Independence Day to all of you Americans and to everybody else. Thanks for being here. We've lots of important stories to share with you. The Vatican's defense attorney in the United States received a major setback this week when the Supreme Court declined to hear the Holy See's appeal of a sex abuse lawsuit filed against it. Here to discuss what this could mean for the Vatican and Pope Benedict personally is author and attorney Mr. Robert Bennett. And later, we'll cover the Senate confirmation hearings held this week for Supreme Court nominee Elena Kagan. Carrie Severino, Chief Counsel for the Judicial Crisis Network, and Ed Whalen of the Ethics and Public Policy Center were at the hearing, and they'll be here a little later to discuss what transpired and what kind of justice Ms. Kagan might be. So let's get started. Here's the brief news from the world over this week. The U.S. Supreme Court has declined to hear the Vatican's appeal of an Oregon judge's decision allowing a sex abuse victim to proceed with a lawsuit against the Vatican. The Supreme Court rejected the appeal without comment. The judge in the Oregon case ruled that the Foreign Sovereign Immunity Act, which typically shields states from litigation, would not apply if it can be demonstrated that the abusing priest was acting as an employee of the Vatican. Vatican lawyer Jeffrey Lina expressed confidence that the court would eventually recognize that a priest is not a Vatican employee. And in Kentucky, the Vatican has asked a federal judge to reject a plaintiff's request to depose Pope Benedict for a clerical sex abuse case there. In this case, the plaintiff is arguing that bishops are Vatican employees, and thus the Vatican is liable for bishops who purportedly did not protect children from abuse. Lina called the plaintiff's arguments speculative confabulations mixed with conspiracy theories and pointed to thousands of documents that have yielded no evidence of any sort of Vatican cover-up. More about the U.S. cases and the ongoing crisis elsewhere in our next segment. And the Elena Kagan Supreme Court nomination hearings wrapped up on Thursday without any track record as a judge and an avowed progressive political leaning. Republicans on the Senate Judiciary Committee seem more concerned about what kind of Justice Kagan would be on the court. During the hearings, Kagan defended her ban of military recruiters as dean of Harvard Law School over its don't ask, don't tell policy, and she avoided questions about same-sex marriage. Perhaps the most interesting exchange of the week came later when Senator Hatch confronted Kagan on a partial birth abortion memo. We'll get into all of that later in the program, and it is most interesting. And in other news, the U.S. Bishops' Conference is urging the removal of an amendment from a defense spending bill that would allow abortions at military hospitals here in the United States and at bases around the world. On behalf of the bishops, Cardinal Daniel DiNardo of Galveston, Houston, said the amendment was misguided and pointed to assurances from the president and congressional leaders during the health care debate that the federal government would not fund or promote elective abortions. The language currently appears in the Senate version of the bill, but not in the House version. The elective abortion ban has been in place since the Reagan administration. And in other news, the European Court of Human Rights is weighing in on a couple of high-profile cases. On Wednesday, Italy and 8 other European nations appealed to overturn the court's recent decision against the display of crucifixes in Italian public schools. A 7-judge panel on the court ruled that the display violates religious and education freedoms and that it could be disturbing to non-Christian or atheist pupils. Italy had argued that the crucifix is a national symbol of culture, history, identity, tolerance, and secularism. The Vatican denounced the initial court ruling, saying that the crucifix was a fundamental sign of the importance of religious values in Italy, and that the crucifix is a symbol of unity and welcoming all of humanity. The appeal will be decided by a 19-judge panel. A decision is expected by the fall. And this past week, the court unanimously ruled that European countries are not obliged to marry same-sex couples. The ruling closed the case of a gay Austrian couple who argued that the Viennese civil code limiting marriage between persons of the opposite sex violated their right to marriage. The court noted that a country's decision to limit marriage to heterosexual couples, is laid out in the European Convention on Human Rights. They further ruled that the convention does not require any sort of equal status of government-recognized same-sex couples to those who are married. In a related note, back stateside, the Wisconsin Supreme Court this week upheld its voter-approved ban of same-sex marriages. And big changes are going on at the Vatican this week. Pope Benedict XVI has chosen Cardinal Marc Ouellet of Canada as the new prefect for the Congregation of Bishops. He will be replacing the retiring Cardinal Giovanni Battista Re. This is an important position, the third most senior in the Vatican. Among his responsibilities, Cardinal Ouellet is charged with advising the Holy Father on bishops' appointments around the world. It's a very important post. He was previously Archbishop of Quebec and Primate of Canada since 2002. He is now the highest-ranking Canadian prelate in the history of the Church. And on Monday, Pope Benedict confirmed the creation of a new office of the Roman Curia, the Pontifical Council for the New Evangelization. The Holy Father said that the new council would be devoted to spreading the gospel message where the faith has suffered from the inroads of secularism and what he calls the eclipse of God. In other words, the council is responsible for the not-so-little task of re-evangelizing the Catholic faithful in the West. Archbishop Renato Fiscianella will serve as the council's first president. The 58-year-old Italian is known for being articulate, and he is the former president of the Academy for Life at the Vatican. And in other news, this week, Swiss Bishop Kurt Koch was named the new president of the Pontifical Council for Promoting Christian Unity. He replaces the now retired Cardinal Walter Casper. And the Holy See's permanent observer at the United Nations in New York, Archbishop Celestino Migliori, has been reassigned. He is now the nuncio to Poland. And British television is about to take two turns for the worse. The Daily Telegraph is reporting that the BBC is planning a 90-minute courtroom drama centered around Pope Benedict going on trial for covering up priestly sex abuse. A BBC spokesman denied any knowledge of the project, even though a producer for the BBC drama admitted being involved with the project. The working title? The Pope on Trial. It must be some other pope. And Channel 4 in Britain has recently commissioned a documentary on Pope Benedict. The lead producer of the project is Peter Tatchell. He's a gay rights campaigner and an outspoken critic of the Vatican who recently called the Pope the ideological inheritor of Nazi homophobia, end quote. Tatchell also spoke of his plans for the upcoming papal visit. He said he'd like to stop the papal mass and arrest the Pope. Nevertheless, Tatchell promises his documentary will be robustly factual. We'll see. And finally, Rio de Janeiro's iconic Christ the Redeemer statue is back in plain sight after a 4-month, $4 million renovation. The newly restored statue was officially unveiled on Wednesday with a rededication mass. Rio's mountaintop statue, the monument, has been under wraps as workers repaired the eroded face and hands of the 79-year-old statue. The renovations came with a new multicolor lighting system, not unlike that found at the Empire State Building. We assume the Archdiocese of Rio will be okay honoring Mother Teresa with her colors on her 100th birthday celebration. We'll see there, too. When we return, a Vatican appeal of a sex abuse case is denied by the U.S. Supreme Court. What does this mean for the Holy See? And could the Pope be deposed? Attorney, author, and former National Review Board member Robert Bennett is here to tell us. The World Over Live continues in a moment. Stay right there.
Now, once again, Raymond Arroyo.
Our first guest is a partner at the international law firm of Hogan Lovells. He was a member of the U.S. Bishops' National Review Board from 2002 to 2004, and he's the author of a terrific memoir, In the Ring, The Trials of a Washington Lawyer. Here to give us his take on the setback incurred by the Vatican's defense team this week and whether the Pope could be deposed is Robert Bennett. Bob, thanks for being here.
Hi, Raymond.
Great to have you back. Now, the Supreme Court this week ruled that they refused to rule on this lower court case. The Vatican was begging the question of whether they have diplomatic immunity or not, and whether they should be subject to lawsuits or not. This is a 2002 case in Oregon. Your thoughts on how important this refusal by the Supreme Court is?
Well, I think it's a very important decision that's very harmful to the Holy See and possibly the Holy Father. What it doesn't mean that the Holy Father will be deposed, and it doesn't mean that eventually the cases will be lost. But what it does mean is, by this denial of review, what the court is saying is these district court judges, we now have one in Kentucky, we have one in Oregon, and there will be others probably as a result of this decision, that the plaintiff's lawyers can engage in discovery, which is a legal term meaning they can ask questions and take depositions. And what it does, Raymond, is
so the discovery moves forward. Elaborate a bit more on that. What does discovery mean, Bob?
What discovery means is that either by taking testimony under oath in what we call a deposition, or by sending written questions, which get answers under oath, and more significantly even, is requests for the production of internal documents. These will, in large part, be turned over. And there are four, I think anyway, there are four areas that is opened up by this decision, which the Church has tried to keep secret or confidential. One is, how does the Vatican work? Two, how much influence does the Vatican have over priests? Because after all, that's a critical issue here.
Right, we're going to get into that in a moment.
Third, how do they deal with reports of abuse? And finally, how do they deal with priest abusers? And that's all fair game now. And they're going to be able to get into the guts of the Vatican and get a lot of information. And it is not out of the question that the Pope someday may well have to be deposed. No other religious leader in the country can claim immunity from that. President of the United States here, my former client, couldn't get away with it, and it's entirely possible that it will happen to him, especially since a number of years ago he, as Cardinal Ratzinger, was put in charge of an entity which was
laicized priests who were offenders.
Precisely right.
And he was direct, and so the Vatican was directly doing that.
Yes, definitely.
Let's talk for a moment now. Jeffrey Lena, who is the representative in the United States for the Holy See and the attorney, he claims that even though the Supreme Court refused to hear their plea, this does not in any way mean that the immunity question, whether the Vatican as a sovereign state has diplomatic immunity, is not at all settled, that it's not through. Your thoughts?
Well, it's still arguably, an open question. but there are exceptions to immunity under that act. But you cannot make light of this decision. What Mr. Lena was hoping for was the Supreme Court taking the case and deciding just,
swatting it away.
And discovery, as we've just explained it, is a very dangerous thing for the church. And you're going to open up all sorts of files. You certainly will be able to depose bishops all over the country. And it's a disaster. And the thing you have to understand with the strategy of the plaintiffs' lawyers is in this country, this stuff is generally done publicly. You have to go into a courtroom and ask that something be sealed. And courts are very reluctant to do that. And every deposition, every inflammatory document is going to be a front-page story in some newspaper somewhere in the world.
Right. Well, we see it this week. There was a large piece on Pope Benedict in the New York Times again today. There seems to be a continuing cycle of this. Jeffrey Anderson, who is the main plaintiff's attorney, who has represented many victims, alleged victims and actual victims of this abuse, said, referring to the Supreme Court appeal, today's action by the justices is an answer to prayer to literally thousands of survivors and sex abuse victims. He is playing this out in the public arena. He is out there on television, on radio. He's giving interviews. He's leaking information to his surrogates in the media. Where is the other side?
Well, I don't know, Raymond.
And does that concern you, that there's no other side here in the public realm?
It does concern me. I'm baffled by it. And I'm absolutely baffled. I'm not faulting Lena. Maybe Lena's under instructions not to say anything. Somebody has got to be saying something, and there's a lot to be said. But when you read this extensive article in the New York Times today, there's nothing in response. And I will tell you, I dealt with one of those reporters during my time on the National Review Board. She was Lori Goodstein. She was very willing to listen to the other side and put quotes in if she felt the relevant. And I had nothing but a decent experience with her. So,
but you've got to bring the other side. But you need an authoritative voice arguing the Holy See's position.
Yes, and they don't. And they usually, these particular reporters usually want the other side. But the thing that I think we're losing sight of, not you, because I know where you stand on much of this, is the moral authority of the church and the bishops is going down the drain. In your opening segment, you went through a whole litany of things, the crucifix, whatever. The words of bishops and cardinals just don't mean what it used to mean. And I think this is one of the effects of this terrible sex abuse
and the public onslaught of it, and no response.
No response, and there are many responses that can be given.
Now, did the Holy See, in its position, in its legal position, hanging everything on the immunity clause here, hoping that Sovereignty Act would save them, did they injure themselves by carving out such a narrow line of defense, if you would?
Well, I don't know. In terms of going to the Supreme Court, that was probably the best argument that they had. Now, they'll have other arguments in the lower courts below, but I don't have any confidence that it will be made.
Well, they're making the same case in this Kentucky case this week in a separate matter, a separate sex abuse complaint. The same argument has been put forward there, that the Vatican has immunity, and it's the same attorneys, Jeffrey Lena, making the same argument. My question is, now that the Supreme Court has said we won't hear it, will that influence the Kentucky case?
I don't know if it will influence the Kentucky case, because in that case, the Supreme Court had already denied cert. But it's certainly going to encourage more suits. You know, there's an analogy here, Raymond. I had the fortune of representing President Clinton. He had very able counsel before I got in. The plaintiffs and the people who wanted to defeat him, the whole thing was to defeat President Clinton in the 1996 election. And the inner circle, including the president, felt, what good does it do me to win a lawsuit in 1997 if I've lost the election in 1996? And there are some similarities, and that's why I was brought on to be, not only a lawyer, but a public spokesperson on many of the issues. And of course, he did go on and win the 96 election. It's even much more serious here.
Yeah.
And maybe they'll win in some cases, but I mean, they're just getting killed from a public relations, which impacts cases. Jurors sit, they're influenced by the public.
Ed from Pennsylvania is calling in. Go ahead, Ed. What's your question?
Mr. Bennett, I'm wondering, do you think it would be wise for the Holy See, the Pope, to postpone his trip to Great Britain? Or it might be too late, but because of the judicial threats, and there might be a rogue judge that might try to do something that would be not effectual, but pretty embarrassing for the Pope.
Well, that's a very troubling question. The fact that you have asked the question, a question which would never have been asked 10 years ago, tells you something. Yes, I mean, I suppose wherever the Pope goes, his advisors have to think about the likelihood or not of some crazy judge taking some kind of action.
No, it's the first
Do I
thing
think
I
it's
thought.
likely? No, but it's something you think about now that you never would have thought about.
No, it's the first thing I thought. It will no doubt limit some of his travel and cause a question to at least be considered before they say, oh, absolutely, we'll come there or we'll come there, particularly in the Western world.
Yeah, and they probably are asking the host countries, if such and such happens, what are you likely to do?
The key to this case, this case that the Supreme Court refused to hear the appeal, this Oregon case, is the notion that a priest is the employee of the Vatican. I want you to listen to Jeffrey Lina. This is the Vatican's counsel and lawyer here in the United States. Here he is explaining this notion to Vatican Radio. Listen.
Now, the factors that generally determine whether a person is an employee include day-to-day control of the person, payment to the person for services rendered, insurance, who is getting insurance for the person, the understanding of the parties as to whether or not they're employees, and there are a variety of other factors. None of these factors are met really in this case. This is a priest who was entirely unknown to the Holy See until after the events in question.
Bob Bennett, is there an argument to be made that a priest is an employee of the Vatican?
Yes, I think the word employee throws you off, and Mr. Lina did accurately identify 4 or 5 factors which weigh in favor of the Holy See. But there are about 15 or 20 others which he did not mention, which could cause a real problem, such as, do they exercise control? If a priest stands up on Sunday and says something contrary to what the Vatican, the doctrine of,
the teachings of Rome on a given
teachings
subject.
of Rome, they may very well be called to task at the Vatican. I mean, I know people who have supported political candidates or signed on a particular bill, and the Vatican didn't like it, and they were on the next plane to Rome. Those are the kinds of factors. It's not just whether you're strictly an employee, but it's whether you are influenced heavily by, do they have ultimate, who laicize priests?
Right,
but wouldn't
the argument here, I mean, the plaintiff's argument here, Bob, would be that the Vatican's, let's assume that they are employees, okay? Let's assume that a priest is an employee of the Vatican.
Right.
The argument here is that employment led to the abuse and its cover-up. That's a bit of a stretch, isn't it?
That's just not the law, and that's just not how it works. Somebody, under the doctrine of what they call vicarious liability, somebody can act contrary to the policies of their employer, but if it's within the scope of their employment, they can be found liable. I mean, the law is very clear on that. And so what I think the plaintiffs will probably, I don't want to give Mr. Anderson any ideas, although he doesn't need me. He seems to know this stuff pretty well, as you ask the question of, well, who can lay aside a priest? I always understood it has to be approved in Rome. That's influence, that's control of one's livelihood.
How would you argue the opposing position? If you were called tomorrow and asked by the Holy See to offer an argument in these cases, what would be your general approach?
Well, I think you would make many of the legal arguments that were made, but I think you have to take this outside of the narrow framework of technical legal arguments on employer-employee. You have to have the word public relations is not a word we like, but you have to have a strategy of communication.
To reset the narrative.
To reset the narrative. That's what I was looking for. To reset the narrative. The problem with the posture you have now is these important decisions are going to be made on a case-by-case basis. And you let these plaintiffs' lawyers into the Vatican files, which I think clearly they'll get there with the denial of this decision.
Really? You believe that via this Oregon case that they'll have access to all of these files?
I don't want to say all of the files, but they certainly will have access to an awful lot of information.
Bob, how does a court, how does a United States court, or a court in London, or a court in Paris, or a court in Ireland compel another city-state to open up files if it doesn't want to?
Well,
I mean, do they then go to the EU? Do they go to another international body? I mean, how do they compel them?
Well, if you want to draw analogies, if a foreign company has a branch here in the United States, there's ample law out there that you can require documents from abroad. And what makes you think that the authorities in these foreign jurisdictions won't agree and say yes?
And once you remove the immunity cover, it's really Katie bar the door.
Yeah, I mean, I think there are arguments to be made, but I think you can't take any confidence in it at all.
Where do you see this going in the final analysis? You think we're headed to open discovery, I imagine a slew of more coverage, like the negative coverage we've been seeing, and maybe a deposition of a pope, or certainly
I certainly
bishops.
think that's possible. I definitely think you're going to have bishops deposed. I think there is a strong likelihood, you're asking me to guess a little bit, that many documents will have to be produced which heretofore would not have been produced.
No, it is a terrible situation.
It's a very bad situation, and the church is just not defending itself, and in my humble opinion.
Well, we will certainly keep our eye on the situation. Thank you for coming and for
It's always
offering
a pleasure.
your insight.
Thank
as
you.
always, Bob's book, In the Ring, The Trials of a Washington Lawyer, is available at bookstores everywhere. When we return, we'll discuss the Elena Kagan Senate confirmation hearings with Kerry Severino and Ed Whalen. The World Over Live continues in a moment. Stay right there. Thank you, Bob. Great stuff. Great. No, it's pretty good.
Now, once again, Raymond Arroyo.
Welcome back to The World Over Live. We watched Elena Kagan's Senate confirmation hearings this week as she could possibly become the next Supreme Court justice in the Supreme Court here in the United States. Two observers at those hearings and experts in the field join me now. Carrie Severino is the chief counsel for the Judicial Crisis Network, and Ed Whalen is a regular on the program. He's president at the Ethics and Public Policy Center. They both clerked for Supreme Court justices. I thank you both for being on the program. Now, tell me, first of all, should a judge be judged by the empathy in their heart, as the president advanced a few weeks ago?
Well, even Elena Kagan admitted that is not what a judge's job is supposed to do. The president said 95% of the way the law will get you there. The last 5% is empathy. She said not at all. It's law all the way down. And on that, I would agree with her. I just hope that that's the kind of justice she would prove to be.
Ed, your overall impression of the questions submitted to this nominee, Elena Kagan, this week, and how would you judge her performance?
Well, I think the key is less the questions than the answers. Elena Kagan, 15 years ago, had explained that she thought that it was essential that the Supreme Court engage, the Senate engage Supreme Court nominees in a meaningful discussion of legal issues. She changed course here and said, I just can't comment on anything. I can't express my legal views. Senators acquiesced in that. So in many respects, the hearing turned out to be a big nothing. There was some information we got, but she really didn't show much indication of what her legal views would be.
There was a lot of very odd questions. I mean, Klobuchar asking what Kagan thought of the Twilight movie and what side of the Jacob-Edward divide she stands on. I mean, this kind of frivolity, really, should this have any place in a Supreme Court judicial hearing?
Well, no, and I think sometimes the senators confuse what's going on in the process of is it a showcase of their witty comments, or is it really something to find out information, or is it just a way for them to get on the soapbox for a while? They know they're on C-SPAN, and they get to say whatever has been on their heart or in their interest to say for a while. So a lot of times you'll have questions that are many times longer than the answer they receive.
I want to get into some of these substantive questions, but before I do that, Ed, your thoughts on her general approach. She seemed to have a bit of a swagger. She was very at ease and confident. I mean, usually, to my eye anyway, there's a bit more reticence and reserve, humility that one sees, no matter who the judicial nominee might be.
Well, Elena Kagan is very self-confident. I think she's had ambitions over the years, and her success has matched her ambitions. I think in this case, she knows that with 59 Democrats in the Senate, she's a very safe bet to be confirmed. She knew that Chairman Pat Leahy would run interference for her at every turn and help set the tone for the hearing that really helped her along. So, yes, she projected self-confidence, perhaps a little too much in terms of interrupting senators to offer her own jokes. But she was in an environment in which she could get away with it.
I want to get right into the substance of this. This is a little exchange she had. And, Carrie, you wrote about this week. Orrin Hatch, the senator from Utah, offered up some questions about a memo she wrote while Kagan was working in the Clinton administration. And this touched upon partial birth abortion. What is the source of the controversy here?
Well, during the attempt to ban partial birth abortion when Clinton was in office, there was a big question of whether the ban would pass and whether he would sign it, first of all, which Kagan was really involved in helping to encourage him not to sign a ban until there were some amendments that were passed that would have created a health exception, typically big enough to drive a truck through, that really would have undermined the entire law. But one of the key pieces in that legislation was a statement by the American College of Obstetrics and Gynecologists, which would have said the medical opinion as to what partial birth abortion was about, whether it was necessary. The original statement that they for some reason sent to the White House, they sent their draft, and it said that they couldn't think of any reason it was medically necessary to ever do a partial birth abortion. She said this would be a disaster. We can't have it go out like this. Didn't even want to show it to the president like that. And then there's an alternate text in her handwriting saying, why don't we put something like this? And this is what ended up being in the document that said that there may be cases in which, however, it is the best option for a woman's life or health.
And this would later be used in 2000 by the Supreme Court and cited as an objective medical study and piece of scholarship to justify overturning Nebraska's ban on partial birth abortion.
That's absolutely right. It played a big part in the litigation, and the supporters of partial birth abortion kept hiding behind the claim that science compels our position. The science turned out to have been politics with Elena Kagan at the wheel.
Orrin Hatch tried to get to the roots of the science or non-science. Here he is talking to Elena Kagan, and the ACOG referenced here is the American College of Obstetrics and Gynecologists. Take a look.
Who did not believe that partial birth abortion was an essential procedure, and who believed that it was really a brutal procedure. And it was a constant conflict there. And as you know, many in Congress came to the conclusion it was a brutal procedure, too, that really was unjustified. That bothers me, that you intervened in that particular area in that way. Well, that's all I'll say about it, but I just wanted you to be aware that that bothers me.
Senator Hatch, there was no way in which I would have or could have intervened with ACOG, which is a respected body of physicians, to get it to change its medical views on the question. The only question that we were talking about was whether this statement that they were going to issue accurately reflected the views that they had expressed to the president's staff, to Congress, and to the American public. I do agree with you. This was an enormously hard issue. And President Clinton found it so and thought that the procedure should not be used except in cases where it was necessary for life or health purposes.
Ed, what are you hearing there? What did she say? I mean, she initially said she would never dream of intervening in this group's decision, and then said, but I did on this occasion, yes?
Well, the record sure seemed to indicate that. Really, at every turn, she was massaging the language, getting what she needed in there. And then when this language was then relied upon in the court cases, she wasn't out there saying, oops, this isn't the medical testimony that you think it is. I mean, the Clinton folks just sat back and let the game play out.
Carrie, there's no doubt that she is militantly pro-choice, I think, where abortion is concerned, yes?
Oh, absolutely. If you look at her recommendations there, her view of what type of health exception was required is a very extreme view of really abortion on demand. It boils down to, I think, much farther even than the constitutional law necessarily was at the time. She seemed to really believe that you had to have a lot of exceptions to have any kind of regulation.
To shed some light on her feelings about abortion, here's an exchange earlier in the week with Dianne Feinstein, the senator from California, and the nominee, Elena Kagan.
Do you believe the Constitution requires that the health of the mother be protected in any statute restricting access to abortion?
Senator Feinstein, I do think that the continuing holding of Roe and Doe versus Bolton is that women's life and women's health have to be protected in abortion regulation. Now, the Gonzalez case said that with respect to a particular procedure, there was that the statute Congress passed, which passed a statute without a health exception and with only a life exception, was appropriate because of the large degree of medical uncertainty involved.
Because of the procedure.
Because of the procedure. But with respect to abortion generally, putting that procedure aside, I think that the continuing holdings of the court are that the woman's life and that the woman's health must be protected in any abortion regulation.
What do you make of that, Carrie?
Well, what we saw here actually was the typical way she answered any question about any constitutional issue. She recites the law and she just says, "Well, this is standing law. This is the law I will have to follow." But I think there's no question that that's also a law that she would independently support. In fact, later in the confirmation hearings, there was a question because the right to privacy in abortion is founded on such bizarre emanations of penumbras from other rights. She wouldn't even admit that she would have believed that. I mean, I think the whole time she's been trying to present herself was more moderate and conservative than she is. But she did say, I have no problem finding the right to abortion elsewhere in the Constitution. I think liberty is broad enough to cover it. So, I mean, if liberty covers the right to kill your own child, I think that's a pretty broad interpretation.
Raymond, I would add a couple points. One is that it's essential that people understand that this so-called health exception is a big phony. It relates to economic circumstances, all sorts of things broadly defined in the judgment of the abortionist. So no one out there should think that what we're talking about is something that's genuinely concerned with serious health risks. It's an entirely huge loophole. The second thing I'd emphasize is that in most areas of the law, understanding is that laws can be enacted, and if there's some hypothetical or rare circumstance in which the law might operate in an unfair way, that's not a reason to strike down the entire law. But there's a special rule that's been developed in the abortion context where folks can dream up these crazy hypotheticals, and next thing you know, legislators can't legislate, and this crazy hypothetical strikes down the real applications of the law.
Well, one of the primary complaints against Elena Kagan, because her record was so thin and having no judicial experience, they went back to her record when she was a clerk on the High Court and later as the dean of the Harvard Law School. One of her notorious moves was ejecting the military recruiters off of the Harvard Law School campus. Senator Cornyn of Texas asked her about this.
But if the policy had no impact on recruiting at Harvard Law School, what possible purpose could it serve other than to stigmatize the military? In effect, you provided a separate but equal means of providing access to students on the campus.
I think the purpose of the policy was something different, was certainly not to stigmatize the military. The purpose of the policy was to express support for our students who were being discriminated against, for our gay and lesbian students who wanted to serve in the military. And the policy was meant to support them or to support, with respect to other employers, any other students who were being discriminated against, and to say, we support those students, and at the same time, to ensure that our students who wanted to go into the military had excellent access to military recruiters and vice versa.
If Elena Kagan was so concerned about the don't ask, don't tell policy, she worked for the president who signed it. She was working for Bill Clinton. Why didn't she resign?
She didn't resign in protest. She never stopped any of the senators who voted for it or the president who signed it from coming to campus. And this honestly wasn't something the military had any discretion about. It's a federal law. They had to follow it.
Ed, your thoughts? What does this tell us about this? What here is germane to her judicial philosophy?
Well, I think what we see is that she elevated her own ideological bias on gay rights above the law. Now, her defenders would say, oh, well, she didn't really kick them off the campus. She instead required that they work through this Veterans Association. Clearly a second-class option. And I think this is just one of several examples that shows that she will indulge her ideological biases. She's done that as Solicitor General. And there's every reason to think she'll do that as a justice. Now, she says, as Carrie said, that it's law all the way down. But in her view, law encompasses all sorts of things that most people wouldn't understand to be law.
It's a very malleable thing, depending on the social situation or the culture that one finds themselves in.
Exactly. So it's a clever phrasing on her part, but there's just nothing in her judicial philosophy and her approach that suggests that it's going to be constrained at all.
Carrie, tie the don't ask, don't tell protest to her view of marriage, which will no doubt come before this court. Gay marriage moving through the courts right now and being challenged in some areas of the country.
Oh, certainly. I think there's a lot of reasons to be concerned about the way she would rule in that case. First of all, because she said in that case that she believed that the don't ask, don't tell policy and eliminating practicing homosexuals from the military was a moral injustice of the first order. So this is something she finds to be a very fundamental problem. She also has talked in other cases when she talked about religion clauses that she thinks if you make too many exceptions for religious groups, that can cause establishment clause violations. So it's essentially establishing religion. Well, one of the next big things is going to be if you make exceptions for, say, religious organizations who don't want to provide benefits to same-sex married partners or who don't want to play along with states that are doing it, or other states that say we don't believe in that, we don't want to recognize it. Is that going to be establishing a religion? That's a real concern for the way she moved.
Ed, before we run out of time, let's talk about the Commerce Clause. She had some discussion about this. First, remind people what the Commerce Clause covers and how this impacts the reach of government into our daily lives.
Well, the Commerce Clause refers to one of Congress's enumerated powers in Article 1 of the Constitution, the power to regulate commerce among the states. And it's been interpreted very expansively, no question, especially since the 1940s, to impose almost no limit at all on Congress. She's made clear that she sees it as limitless. And what's interesting, I think, is the contrast between her view there that Congress can do anything and her view in other areas, except there are these certain protected things that no one, Congress of the states, can possibly touch. I'll just say on same-sex marriage, which I think is a huge issue, she was involved in the formation of a brief last year in a very important case that abandoned grounds for defending the Defense of Marriage Act. An ardent proponent of same-sex marriage described the Department of Justice's brief as a gift to the gay marriage movement. She was duty-bound to defend that law vigorously. She said she was going to, but she, by her own testimony, was involved in the process of approving the brief that abandoned these grounds, the grounds of procreation and raising children as essential rationales for what marriage is.
Fascinating. Before we go, this being Independence Day weekend, there was a little exchange with Senator Coburn about the Declaration of Independence and the inalienable rights suggested there, indeed laid forth there. Take a look.
I'm not asking you about your judicial. I'm asking you, Elena Kagan, do you personally believe there is a fundamental right in this area? Do you agree with Blackstone that the natural right of resistance and self-preservation, the right of having and using arms for self-preservation and defense? He didn't say that was a constitutional right. He said that's a natural right. And what I'm asking you is, do you agree with that?
Senator Coburn, to be honest with you, I don't have a view of what are natural rights independent of the Constitution. And my job as a justice will be to enforce and defend the Constitution and other laws of the United States.
So you wouldn't embrace what the Declaration of Independence says, that we have certain God-given inalienable rights that aren't given in the Constitution, that they're ours alone, and that the government doesn't give those to us?
Senator Coburn, I believe that the Constitution is an extraordinary document. And I'm not saying I do not believe that there are rights pre-existing the Constitution and the laws. But my job as a justice is to enforce the Constitution and the laws.
Well, I understand that. Well, I'm not talking about as a justice. I'm talking about Elena Kagan. What do you believe? Are there inalienable rights for us? Do you believe that?
Senator Coburn, I think that the question of what I believe as to what people's rights are outside the Constitution and the laws, that you should not want me to act in any way on the basis of such a belief.
I would want you to always act on the basis of a belief of what our Declaration of Independence says.
I think you should want me to act on the basis of law. And that is what I have upheld to do if I'm fortunate enough to be confirmed, is to act on the basis of law, which is the constitutions and the statutes of the United States.
Go ahead, Ed. Comment on that.
Well, I think it's just striking that when Senator Coburn invited her to express her personal view that she embraced the principle in the Declaration of Independence that we human beings have inalienable rights, she wouldn't take that step. She kept diverting it to what she would do as a judge. And I think it's just a striking illustration of the gap between the modern left, the progressives, and American values. And Elena Kagan is not unique in this regard. I think this is an area where she didn't even have the instinct to understand how alien her view was, because the legal academic world is so removed from the American understanding. And what we're seeing, I think, with the Tea Party movement and the reaction against what's going on in this country is people seeing how far our political class has moved from these basic values. And now suddenly you're going to have Democratic senators run off on the 4th of July to go to their constituents in these elaborate ceremonies and talk about the Declaration, and then come back to vote to confirm someone who doesn't believe in our national creed as expressed in the Declaration. It's an amazing situation.
Breathtaking. Carrie, you have the last word. What kind of justice will she make?
Well, as we said in the Declaration, she doesn't believe that there are rights that even pre-exist our government. That suggests she believes in a very expansive government. I fear she would just be one who would rubber stamp a lot of Obama's policies and the expansive agenda that we've seen so far, including abortion, including maybe same-sex marriage, and a lot of issues that people should be very concerned about.
Ed, any doubt that she'll be confirmed?
You'd have to give me pretty high odds to bet against it.
Okay, very good. Thank you both for being here. For more information on the Judicial Crisis Network, Carrie Severino, and all of her work, visit their website, judicialnetwork.com. And, of course, you can always find Ed Whalen's great materials either on the National Review website. He does great bench memos, so does Carrie occasionally, or on the Ethics and Public Policy Center website at eppc.org. Thanks again, both of you, for being here. I'd like to wish you and your families a very happy and safe Independence Day. Our thoughts and prayers go out to all the men and women in the U.S. Armed Forces who put their lives on the line for us every day in the service of freedom. Thank you all and your families. God bless you all. Until next week, you can find updates and the occasional commentary by following me on Twitter at twitter.com/Raymond Arroyo, or you can check out the Facebook page. Those of you who follow us not only get previews of our shows, but additional material by our guests, and you can always find me at RaymondArroyo.com. On behalf of the staff and crew of EWTN News, I'm Raymond Arroyo. We'll be scouting the world over for all that is seen and unseen. Stay tuned. We'll see you next time. Bye now.
Thank you.